Good afternoon, everyone. We're delighted to welcome you to the third webinar in our Procurement Reform series. This webinar will take a look at some of the key elements of the Procurement Reform Scotland Act 2014 and how it dovetails with wider procurement reform in Scotland. There's one further seminar which is scheduled for Thursday the 21st of April, where we will consider how to protect against bribery and corruption in infrastructure projects. This webinar is being recorded and will be available on our Vimeo site. Details of how to access these are on the screen and will be given again at the end. Before we begin, there are a few housekeeping matters to start with. To minimise background noise, I've placed you all on mute. If you'd like to ask any questions, please do so using the webinar chat function. In order to keep within the relevant time slot, we'll try to answer questions at the end of the presentation rather than as we go along, or alternatively, we'll follow up the questions separately after the webinar. So, in terms of your speakers, I'm Euan Murray. I'm a Senior Associate in the Construction and Special Projects team, specialising in public procurement and infrastructure, based in Edinburgh. Rona Harper, the partner that heads my team, also specialises in procurement and is based in Glasgow. Rona and I have, between us, presented the webinars in the Procurement Reform series so far, and our colleague Judy Craig will be presenting the final webinar in the series next week, which, as mentioned, will cover how to protect against bribery and corruption in infrastructure projects. So, moving forward to the agenda for today, this is now the third webinar in the series, and in the first two webinars, we looked at some of the changes introduced by the Public Contract Scotland Regulations 2015. In today's seminar, we're going to look at the other half of the Procurement Reform equation, which is the Procurement Reform Scotland Act 2014. We'll take a quick look at what the Act is and how it dovetails with the new procurement regulations. We will then look at some of the key requirements of the Act before moving on to consider the wider landscape in terms of procurement reform and what it may mean for you and your organisation. Hopefully we'll then have some time at the end of the webinar to pick up any questions. So we'll begin with a quick run through of what the Act is itself and where we are in terms of procurement reform in Scotland. As we covered in the first webinar in the series, we now have a new set of procurement regulations which implement the new EU Procurement Directive, and they're known as the Public Contract Scotland Regulations 2015. The Procurement Reform Scotland Act 2014 was published on 4th of October 2013, and royal assent was granted thereafter, but it's been waiting patiently in the wings since then, and it will now come into force on the 18th of April 2016. The Scottish Government announced that it was seeking to take a coordinated approach to the implementation of the new procurement regulations with the Procurement Reform Scotland Act, and as such the Scottish Government has opted to bring the two pieces of legislation into force on the same date. As we will see shortly, it applies a procurement regime to a whole new tranche of contracts that would not ordinarily be caught by the procurement regulations. It's worth flagging at this stage that the Procurement Reform Scotland Act is a separate regime which sits below the provisions of the new procurement regulations, and as such the public sector in particular will need to operate both regimes at the same time and will need to implement all of the changes on the same date. So how does the Procurement Reform Scotland Act fit into the wider picture? Well, in terms of how it dovetails with the new EU-level procurement regulations, as mentioned a moment ago, this is actually a separate regime which sits below the EU-level procurement. The Procurement Reform Scotland Act will apply to regulated contracts, and those are all public contracts with a value above the threshold set out in the Act. Thresholds themselves are £50,000 for any public contract other than a public works contract, and £2 million for public works contracts. As you can see, this is a far lower threshold than the EU-level procurement thresholds, which are at least double these values. This therefore has the effect of applying a regulated procurement regime to a significantly wider set of contracts than the new EU Procurement Directive and the new implementing procurement regulations. Scottish Government guidance did previously set out recommendations for procurements above a value of £50,000, which contracting authorities followed, but the Procurement Reform Scotland Act goes beyond simply codifying that guidance, as you will see. So what does this mean for you? Well, if you're in the public sector, then it means you need procedures and policies in place to cover both the new procurement regulations discussed in previous webinars, as well as procedures and policies in place to cover the requirements of the Procurement Reform Scotland Act. So let's move on now to consider some of the key requirements of the Act itself. The first thing I want to touch on is the procurement strategy. Section 15 of the Act requires each contracting authority that will have a significant procurement expenditure in the next financial year to prepare a procurement strategy setting out how the authority intends to procure its regulated procurements. Significant expenditure is stated to be expenditure that is equal to or greater than £5 million. The Act requires that the procurement strategy is published and that publication must be at least on the internet. That of course means it will therefore be publicly available. The Act itself sets out a number of requirements which the strategy must deliver, including, for example, showing how the authority will ensure that a 30-day payment timescale will be achieved from the top to the bottom of the supply chain. This in particular is interesting as one of the complaints often raised by SMEs in relation to public procurement, who are often at the bottom of the supply chain, relates to cash flow, as payment timescales previously tended to increase as you moved down the supply chain. This requirement will clearly seek to address those concerns. The procurement strategy itself has to demonstrate transparency. It has to show how the authority intends to carry out its regulated procurement so as to ensure that they will contribute to the carrying out of its functions and achievement of its purposes, deliver value for money, and comply with its general duties under the Act. It must also include a statement of the authority's general policy on 1. The use of community benefit requirements, 2. Consulting and engaging with those affected by its procurements, 3. The payment of a living wage to persons involved in producing, providing or constructing the subject matter of regulated procurements, 4. Promoting compliance by contractors and subcontractors with the Health and Safety at Work Act 1974 and any provision made under that Act, and 5. The procurement of fairly and ethically traded goods and services. It has to include a statement of the authority's general policy on how it intends its approach to regulated procurements involving the provision of food to improve the health, well-being and education of communities in the authority's area and promote the highest standards of animal welfare. And I would also flag that there's scope for the Scottish Ministers to specify further matters to be included also. Section 17 of the Act requires the contracting authority to comply with the procurement strategy. The flip side to the procurement strategy is the procurement report. This is covered by Section 18 of the Act and must be prepared as soon as reasonably practicable after the end of that financial year. So what must the procurement report contain? Section 18 of the Act states that it must include a summary of the regulated procurements that have been completed during the year covered by the report, and for the purposes of the Act, a regulated procurement is completed when the award notice has been published or when it otherwise comes to an end. It also needs to include a review of whether those procurements complied with the authority's procurement strategy, and to the extent that any regulated procurements did not comply, a statement of how the authority intends to ensure that future regulated procurements do comply. It needs to contain a summary of any community benefit requirements imposed as part of a regulated procurement that were fulfilled during the year covered by the report. It needs to contain a summary of any steps taken to facilitate the involvement of supported businesses in regulated procurements during the year covered by the report, and a summary of the regulated procurements that the authority expects to commence in the next 2 financial years. Now that means a 2-year look forward for the regulated procurements that you expect to commence in the next 2 following years, and also such other information as the Scottish Ministers may by order specify. Obviously the introduction of the procurement report backs off the obligation in the strategy and introduces a level of public accountability in terms of compliance with the strategy. It's also useful to have the 2-year look forward, both from a public sector perspective in terms of programming future pipeline, but also from a private sector perspective in terms of identifying future work opportunities. It's also worth noting that feedback has to be given to all bidders at PQQ stage now, pursuant to Section 32 of the Act. But in practice, many contracting authorities already provided that feedback as a matter of course. Let's move on now to look at some of the other interesting aspects of the Act. The first one I'd like to cover is the sustainable procurement duty. What is it and what are your obligations if you're a contracting authority? Well, the sustainable procurement duty is set out as Section 9 of the Act, which provides that the sustainable procurement duty is the duty of a contracting authority before carrying out a regulated procurement to consider how in conducting the procurement process it can improve the economic, social and environmental well-being of the authority's area, facilitate the involvement of small and medium enterprises and third sector bodies and supported businesses, and promote innovation. And in carrying out the procurement, to act with a view to securing the improvements identified. Contracting authorities have to consider only matters that are relevant to what is proposed to be procured, and in doing so consider the extent to which it is proportionate in all the circumstances to take those matters into account. In this context, the Act provides that small and medium enterprises means businesses with not more than 250 employees, and that third sector bodies means organisations, other than bodies established under an enactment, that exist wholly or mainly to provide benefits for society or the environment. It also provides that references to the well-being of the authority's area, in particular, include reducing inequality in that area. Many authorities would have considered similar issues in formulating their procurements in the past. However, it's now a specific codified duty to consider this in the context of every single regulated procurement at the outset of the process. The Act also requires publication using the Public Contract Scotland website, and therefore seeks to move towards having Public Contract Scotland as a general one-stop shop for all Scottish procurements. The one thing I'd flag here is that it's worth noting that obviously the Procurement Reform Scotland Act and also the new EU-level procurement regulations apply to Scotland only, and there is therefore a different website for contracts in England and Wales. Now that's important if you're a contractor in the private sector working UK-wide, or if you're a contracting authority with offices, departments or contracts split throughout the UK. One of the other key aspects of the Act relates to requirements for community benefits, and this is covered by Section 25, which provides that specific requirements apply to regulated procurements where the estimated value of the contract is equal to or greater than £4 million. Where this actually applies, the contracting authority must, again before carrying out the procurement, consider whether to impose community benefits requirements as part of the procurement. The contracting authority must, in the contract notice relating to the procurement, include 1. A summary of the community benefit requirements it intends to include in the contract, or 2. Where it does not intend to include any such requirements, a statement of its reasons for not including any requirements. Where community benefits are included in a contract, the contracting authority has to include in the award notice a statement of the benefits it considers will be derived from those requirements. And it's also worth noting that the Scottish Ministers do have the power to modify the figure specified currently in Section 25, and so it could change over time. So although at the moment it applies to contracts above £4 million, this could change. But what is a community benefit requirement? Well, the Act specifies that a community benefit requirement is a contractual requirement imposed by a contracting authority, A, relating to training and recruitment or the availability of subcontracting opportunities, or B, which is otherwise intended to improve the economic, social or environmental well-being of the authority's area in a way additional to the main purpose of the contract in which the requirement is included. Many contracting authorities have developed community benefit requirements over the last few years, and some in fact were able to achieve significant community benefits during the course of their procurements, and this provision of the Act will seek to reinforce that requirement. The next aspect of the Act, which it would be worth considering today, is the requirements relating to the Contracts Register. This is covered by Section 35 of the Act. Section 35 requires each contracting authority to keep and maintain a register of contracts, and it must cover all contracts entered into as a result of regulated procurements. In relation to each contract listed, the register must contain the following information. A, the date of award of the contract. B, the name of the contractor. C, the subject matter of the contract. D, the estimated value. E, the start date. F, the end date provided for in the contract, disregarding any option to extend the contract, or where there is no date specified, a description of the circumstances in which the contract will end. And G, the duration of any period for which the contract can be extended. Now, much of this information will be readily available and to hand in other documents which the contracting authority has throughout the procurement process, but it will be useful to collate them together in one place from a contract management perspective. Unfortunately, it's likely to create an additional administrative burden at the outset on each authority as it collates its first contract register. So when can you delete an entry? Well, an entry can only be deleted from the register once the contract has actually expired or been terminated. The Act also specifies that authorities must make the information contained in the contracts register publicly available on the Internet, and by such other means as it considers appropriate. In terms of withholding information, the Act does provide that specific information can be withheld which the authority considers that making it publicly available would either A, impede law enforcement, or would otherwise be contrary to the public interest, B, would prejudice the commercial interests of any person, or C, would prejudice fair competition between economic operators. As I mentioned earlier, having a publicly available contracts register will be a useful tool for the public sector in terms of contract management, and it will assist in terms of looking ahead to future procurement requirements in upcoming years, as you will be able to see at a glance which contracts are about to expire and whether or not they have potential extensions. The flip side to this is that it's also likely to be a useful tool for the private sector, as they will be able to obtain copies of the relevant procurement strategies and contract registers for each area that they're interested in, and particularly for the clients that they're interested in targeting. And they can ascertain from the information available when the next tender process for any specific project is likely to come to market, as it will clearly specify the original end date and whether or not there is any time period or option for extension. That will hopefully help the private sector identify and target potential opportunities going forward. So moving on now, I'm going to take a quick look at the question of what would be the consequences of breaching the Procurement Reform Scotland Act. We've all seen a number of procurement cases coming out in relation to EU-level procurement, but what would happen in relation to a breach of this Act? Well, proceedings would be brought in either the Sheriff Court or the Court of Session, and the challenger must notify the authority of the relevant failure and the intention to bring proceedings prior to actually raising proceedings. In terms of remedies, the courts can either A, order the setting aside of a decision or action, and or B, order the amendment of any document, and or C, award damages to the relevant person that has suffered the loss or damage. Section 39(5) of the Act provides that if the breach relates to a regulated contract that has already been entered into, then the court can only make an award of damages. What's the risk window in terms of challenge? Well, proceedings must be brought within 30 days of the date on which the relevant person knew or ought to have known that grounds had arisen, or such longer period of 3 months as the court considers appropriate. The Act further provides that a longer period can only be fixed if the court considers that there are good reasons for doing so. Let's look quickly now at the position in the rest of the UK. The Public Contract Regulations 2015 are already in force in England and Wales, and the different regulations mean that there are slightly different regimes applying in Scotland and the rest of the UK. Timescales for delayed implementation of certain provisions, for example, may be slightly different, but in the main the two EU-level regimes will align in many places, as each one seeks to implement the new EU Procurement Directive. However, as we've mentioned, the Procurement Reform Scotland Act sits below the EU regime and only applies in Scotland. So there are different procurement regimes now applying in different parts of the UK. What does that mean in practice? Well, in the short term at least, the public sector should be very clear about processes in their procurement documentation, as the private sector will be trying to adapt to multiple regimes at the same time. And conversely, if you're a bidder operating throughout the UK, targeting contracts and opportunities across the whole of the UK, then you will need to be on top of the various regimes, which will depend on the value and location of the contract you are bidding for. What about further developments? Well, you'll all be glad to know there are more to come in the future in terms of procurement reform. The Scottish Government recently published guidance, and it's likely to continue to publish further guidance on the new procurement landscape throughout 2016. In addition, the Scottish Government and the Scottish Futures Trust are continuing to work on the implementation of a report following the review of Scottish public sector procurement in construction, which was published back in October 2013. In May 2014, the Scottish Government agreed to implement 66 of the 67 recommendations identified in that report, and the one recommendation that was not being implemented was the appointment of a Chief Construction Advisor. Implementation of those recommendations is stated to be split between the Scottish Government and the Scottish Futures Trust, and we understand that it is anticipated that the 66 recommendations that are to be implemented will be implemented by December 2016. For further information on that, there are details available on the Scottish Government's website. So what does all of this mean for you in the wider context? Well, the new regime is likely to lead to a more structured approach to public procurement in Scotland, covering far more contracts than were originally covered. But this, of course, comes with increased accountability, increased audit and reporting obligations. Those increased reporting and audit requirements are likely to mean higher administration costs in a time of ever-increasing budgetary pressures for the public sector. If you're in the private sector and you bid for opportunities throughout the UK, you will now be operating across multiple procurement regimes, which means that you need to be on top of the requirements and processes for each specific regime. In the public sector, each organisation should consider whether it needs to update internal procurement policies and guidance, as well as any required updates to standing orders and schemes of delegation to reflect the new regime. We've now come to the end of the presentation, which we hope has been useful and interesting. If you haven't already done so, please type any questions into the chat box and we'll seek to respond to them now, or alternatively, follow up with you following the webinar. While you're doing that, I'll take the opportunity to remind you that this webinar and many of our other webinars have been recorded and are available on our Vimeo site. So please do share the link with colleagues who you think may find this webinar useful. We'll be circulating details of the recording to all participants after the webinar. We would also appreciate any feedback you have on the format and content of these webinars so that we can continue to improve them, and we are particularly happy to hear your thoughts on topics which you would like to see covered by future webinars, whether that relates to procurement reform or any wider webinar topic. I would also like to remind you that our next and final webinar in the series will take place next Thursday, the 21st of April, at the same time, and it will cover How to Protect Against Bribery and Corruption in Infrastructure Projects, and will be presented by Judy Creek. Well, it looks like we don't have any questions at the moment, but please do feel free to follow up with any questions after the webinar. So I think our time is therefore up for today. I do hope that you've enjoyed this webinar and found it informative and useful, and we look forward to welcoming you all to future webinars.